So the ATF's frames and receivers rule was struck down nationwide as invalid and beyond the ATF's authority. But the ATF is not giving up just yet. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down below if you're interested. As I mentioned in the intro, in this video, we will be discussing the ATF's rule on frames and receivers, which was recently struck down by a federal district court as entirely invalid. Well, the ATF is not yet willing to actually give up on this case, and today they filed for review by a 5th Circuit Court of Appeals, so they've appealed that decision. The case we're going to be talking about in this video is called Vanderstock v. Garland. This is a lawsuit decided by a Texas Federal District Court Judge Reed O'Connor, and the plaintiffs in this case are FPC, and they were seeking a motion for summary judgment against the ATF and their new rule on frames and receivers that went into effect last August. If you're not familiar with what the new rule on frames and receivers is, we've talked about this before on prior videos, but essentially it was the ATF's restrictions on 80%ers, polymer 80s, and also parts kits that could be sold by various manufacturers like Polymer 80, 80% Arms, Defense Distributed, a bunch of other companies. And essentially it was the federal government's attempt to regulate 80%ers, or these so-called ghost guns. Now, as you may recall, in this case, Vanderstock, the plaintiff, sued the ATF and sought for a federal court to find that this new rule is invalid under the Second Amendment. In their lawsuit, the plaintiffs also requested a preliminary injunction from that court to enjoin, i.e. halt the enforcement of the ATF's new rule while this case was making its way through the process. Originally on review, that federal district court judge originally granted a limited preliminary injunction against the ATF. Looking at the ATF's rule initially, he found that the rule on frames and receivers was facially invalid under the plain text of the statute, and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, which was tactical machining. Later, he then expanded the preliminary injunction to protect other individual named plaintiffs and also their customers, as well as tactical machining. And then you had other companies jump in, like 80% Arms, Defense Distributed, and other companies who sought to intervene in the case. And eventually he did permit them to intervene in the case as plaintiffs, and they were given the same type of protections. After the ATF lost that initial battle, they then decided to appeal the granting of those limited injunctions, and they appealed that up to the 5th Circuit. Currently, there is an interlocutory appeal on those issues pending before the 5th Circuit, and that's going to also play into the appeal that's currently going to be taking place with them appealing the granting of the motion for summary judgment. But while this issue was making its way through the 5th Circuit, the plaintiffs continued again, like I said, for that motion for summary judgment. In its simplest terms, a motion for summary judgment can resolve the entire dispute, the entire case, without going to a full trial. Either side can file a summary judgment motion, and that's exactly what happened here in this case, where the ATF, the government, and the plaintiffs here filed for cross motions for summary judgment. FBC and the other plaintiffs sought for Judge O'Connor to strike down the frames and receivers rule in its entirety right here and now, and for him to find it as invalid. And we received recently that decision from Judge O'Connor where he did exactly that. Therefore, he vacated the rule 100%, and that led to essentially a nationwide vacature of that frames and receivers rule. In his decision, Judge O'Connor stated that this case presents the question of whether the federal government may lawfully regulate partially manufactured firearms components, related firearms products, and other tools and materials in keeping with the Gun Control Act of 1968. Because the court concludes that the government cannot regulate those items without violating federal law, the court holds that the government's recently enacted final rule definition of frame or receiver and identification of firearms is unlawful agency action taken in excess of the ATF's statutory jurisdiction. On this basis, the court vacates the final rule. So the main thrust of his decision is that the ATF acted beyond their authority under the GCA, and therefore the rule in its entirety is invalid. One of the important things to note with this decision is that Judge O'Connor did not rule on the ultimate Second Amendment constitutionality of the final rule. I think that's important. Some people may be saying that he found that it's invalid under the Second Amendment, but he didn't actually address that question, even though it was part of the original lawsuit. Ultimately, what ended up happening is he decided it more on an administrative issue as far as the ATF overstepping their authority and their statutory authority, and he didn't even have to get to the Second Amendment question because it was invalid just under the administrative procedures and what the ATF can and cannot do under the plain text of the statute. So he didn't even address or didn't have to address the Second Amendment question. What Judge O'Connor did in this decision is he looked at the text of the GCA and determined if the new ATF rule on frames and receivers was consistent with the actual text. He decided that it did not. He stated, because Congress did not define frame or receiver, the words received their ordinary meaning. Contrary to the defendant's assertion in an interpretive dispute over a statutory term's meaning, the court does not simply leave the precise definition of that term to the discretion and expertise of the ATF. In this section, Judge O'Connor is being very clear that the statute defines what is a frame or receiver, and that's very expressly stated in the text of the statute, and therefore he's not going to defer to the ATF's interpretation of what they want that term to mean. This is good because this decision follows recent trends in federal district courts, in appellate courts, in current trends by judges in not giving the ATF Chevron deference to interpret the NFA and JCA however they want. And since the rule is invalid in its entirety, Judge O'Connor ruled to vacate it altogether, and that decision applies nationwide. Well, we all knew that the ATF was not going to let that decision sit for long, and today we received notice in the case that the government has filed an appeal up to the Fifth Circuit, and they're seeking review of that decision. I suspect that we will soon also get something filed by the ATF attempting to stay the judgment of Judge O'Connor down below. I think it's likely because the ATF does not want the final rule to be, vacated. They want it to still be in effect. However, the decision by the judge there, Judge O'Connor, simply put things back into the status quo prior to what happened in August. So remember, this is a new rule. It went into place August 24th, I believe, of last year. So the decision here by Judge O'Connor simply put things back to the status quo of what the ATF had said was lawful prior. So it really didn't change a whole lot of things. It just simply went back to the old status quo. So it's going to be hard for the ATF to argue that the Fifth Circuit needs to put a stay on his judgment when he simply put things back into the status quo. Currently, the ATF has already appealed the prior injunctions that were granted by Judge O'Connor in this case. That appeal is still pending before the Fifth Circuit. I suspect that the summary judgment appeal will also be consolidated with those interlocutory appeals that are going on right now with the preliminary injunctions, probably going to moot those preliminary injunction appeals, and this will just move forward on the summary judgment appeal. But as things stand right now, the ATF's final rule is vacated in its entirety. The ATF has now filed an appeal of that decision up to the Fifth Circuit, and they're seeking for the Fifth Circuit to reverse that decision by Judge O'Connor. They're also likely going to try to get a stay on that decision while the appeal is currently pending and going through the process. However, our odds are very good because this case is going to be taking place at the Fifth Circuit level. The Fifth Circuit has been very favorable, especially in these ATF rulemaking cases. Recently, the Fifth Circuit en banc panel struck down the ATF's bump stock rule in the Cargill case. Very similar facts, very similar rulemaking process that the ATF engaged in the bump stock issue that they did with the final rule on frames and receivers. And both of these have been struck down. So again, the Fifth Circuit is very favorable. And ultimately, I think the Vanderstock case is going to face the same fate. It's going to be a significant win for us in the Fifth Circuit. And then the question really is, what is the Supreme Court going to do? The Supreme Court currently has the Cargill case also pending before them, dealing with the bump stock rule, the ATF's bump stock rule, and it's going to be interesting to see what they decide to do. But for now, we have a huge win, and we will have to wait and see how the Fifth Circuit decides to deal with this and what they decide to do with the appeal. So if you guys like this video, if you want to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.